With my co-counsel, Randall Young, we represent Thomas and Carol Smith, the appellant and petitioner in this matter. Today, I'll be arguing for 15 minutes, and my co-counsel will be arguing for 15 minutes, 2 of which will be reserved for rebuttal. Today, I'll be arguing on behalf of the Smiths that the trial court erred in determining that it had personal jurisdiction over the Smiths and subject matter jurisdiction to hear the claims against the Smiths. My co-counsel will be arguing that the trial court incorrectly determined that the Yuma Indian Nation, the Economic Development Corporation, or EDC, and its CEO, Fred Captain, and accountant, Molly Bluejacket, were protected by sovereign immunity or any other type of immunity. We respectfully request that this court would overturn the determination regarding the jurisdictional issues over the Smiths, or, in the alternative, if this court determines that there is jurisdiction, they would overturn the trial court's determinations regarding sovereign immunity so the Smiths' claim can be properly heard in Yuma Indian Nation tribal court. At this time, Your Honors, I'd like to waive the recitation of the facts that please do mention.
That's fine.
Your Honor, the Yuma Indian Nation incorrectly determined that it had personal jurisdiction over the Smiths because, first and foremost, the Smiths did not have the minimum contacts necessary for personal jurisdiction by the Yuma Indian Nation tribal court. Secondly, because the Smiths did not reasonably anticipate being hailed into Yuma Indian Nation tribal court and did not purposely avail themselves of this court. And finally, because the requisite nexus between the suit-related conduct and the foreign jurisdiction does not exist, there would be personal jurisdiction in this matter. The Indian Civil Rights Act incorporates a version of most, but not all, of the United States Constitution's Bill of Rights on the Indian tribes. And the Indian Civil Rights Act requires that tribes follow the same basic tests for personal jurisdiction as is applied in federal courts and federal forums. The general rule in this case, Your Honor, is from International Shoe versus Washington, decided in 1945. That meaning that a court may not make a binding judgment over a party with which it does not have substantial ties, relations, and contacts. And minimum contacts has long been the test. Also, the Supreme Court stated in Hansen versus Denver, decided in 1958, that it is the quality of the contacts themselves that determine whether or not a court has personal jurisdiction. And quite simply put, Your Honor, this court does not have the requisite minimum contacts for personal jurisdiction.
Do all of the contacts have to occur on the reservation, or is it enough that the subject matter is connected to the reservation?
Your Honor, we would ask this court to look to the suit-related conduct itself as required to connect the parties themselves to the foreign jurisdiction. That meaning that the disclosure makes the Arizona Attorney General, which led to the breach of contract, breach of fiduciary duties, and breach of confidentiality, would have had to occur within the reservation in order for there to be both personal and subject matter jurisdiction in this case. But still, in regards to personal jurisdiction, Your Honor, the Smiths will contend those disclosures happen outside of the reservation. So this is quite simply put under general federal law that there will not be personal jurisdiction, but also pursuant to other tribal decisional law and federal courts that have come down on personal jurisdiction in regard to Indian tribes.
Counsel, if I can interrupt you, if there are cases that you could point us to under your international shoe analysis where a party would have taken direct payments from the sovereign at question, how would that play out?
Your Honor, in a particular instance, I would look to this. I would ask this court to look to a case such as worldwide Volkswagen and whether or not the tribe originally anticipated being hailed into the court. As far as payments from a sovereign allowing for personal jurisdiction, I don't have necessarily a case directly on court with those facts. However, I would still point this court toward the same analysis as is applied in federal form, so that an individual, the numerous contacts that we have here between Carol Smith and the tribe and Thomas Smith and the tribe were not allowed for personal jurisdiction because they were not originally anticipated being hailed in this court under worldwide Volkswagen versus Woodson, decided in 1981 by the United States Supreme Court.
And as a follow-up question, the consensual relationship test in Montana, would that be met by receiving payments from the sovereign?
No, Your Honor. Thomas Carol Smith, first Thomas would concede that he was in a consensual relationship with the tribe. There are clear enumerated types of consensual relationships in the first Montana exception, and contracts are one of them. However, Carol Smith was not in a contract with the Yuma Indian Nation. She was in a contract with her brother, Thomas. And at no point did she ever provide secure transaction advice to the nation, to the EDC. She provided it to her brother. Would also
but counsel, didn't she recognize that that advice was being given on behalf of the tribe, and didn't she receive direct payments from the tribe for her services?
Yes, Your Honor, she did. However, it's still the Smith's position that Montana and its progeny require a nexus between the consensual relationship and the tribal land itself. I would first point this court towards Dolgan Court versus the Mississippi Band Choctaw Indians, decided by the Fifth Circuit in 2013. Very clearly in that case, Dolgan Court, or Dollar General, had built a store within the reservation and had performed commercial activities on the reservation in the form of both that store itself and an internship program that it had on tribal land. And the court there found that, yes, there was enough contact for personal and subject matter jurisdiction because of the commercial activities that occurred within the reservation. Also, under the Union Nation's own Tribal Code, Section 1-102, 1-104, and 1-107, applying the rules for personal and subject matter jurisdiction and the ordinance of personal and subject matter jurisdiction, all require those contacts occur within the reservation, and that all of the contacts comport with federal law. Turning back to Progeny of Montana, Atkinson Trading Company versus Shirley, decided by the United States Supreme Court in 2001, very clearly capped Montana by geography. The locus of the disclosure themselves is crucial in this court's analysis. A spectrum exists, Your Honors, and what this court should look at in crafting its rule, in crafting its decision on this case. And that spectrum involves two things, Your Honor. First and foremost, the frequency of the contacts themselves and the quality of those contacts. Whether or not they were substantial and pervasive, or whether or not they were individual and de minimis. And the Smiths would argue that they are on the opposite side of that spectrum, where it would be where their contacts would be substantial.
Isn't everything that Smith did, that the Manuel Smith did, under contract that is intended to have its total effect on the reservation?
Your Honor, the contract itself that Thomas Smith entered into was as a financial advisor for the Union Indian Nation. Yes. However, the dealings themselves, the performance of the contract, the entry of the contract occurred off of the reservation, not within the reservation. The disclosures themselves, the suit-related conduct, which we would potentially focus on, all occurred outside of the reservation. And Montana has never allowed for civil jurisdiction over non-members outside of the reservation. And for this court to hold otherwise would be contrary not only to its own tribal code, but contrary to federal precedent. We would also ask this court to look at cases such as Walden versus Flore, decided by the United States Supreme Court in 2014, and Daimler versus Bowman, decided by the Supreme Court in 2014.
But counsel, were the actions taken outside the reservation here that are the subject of suit actually calculated to have effects inside the reservation, which is to prevent the marijuana business from getting off the ground?
Yes, Your Honor, they were. However, the Smiths would contend that still, because that nexus doesn't exist in relation to the suit-related conduct, that there is no jurisdiction. And even if this court were to look at the performance of the contract, it would still argue that the contract or that the Smiths had with the tribe were de minimis.
Doesn't Calder versus Jones stand for the proposition that when you know that effects are going to take place into an area where you sometimes that in fact there is jurisdiction, and isn't this an analog of that case?
This is distinguishable from that particular matter, Your Honor, and I would in fact ask this court to look more along the lines of a case like Waterwheel versus Lorenz, decided by the Ninth Circuit in 2011. And in that particular case, we had a very analogous facts as well. There, an individual, Mr. Johnson, had purchased Waterwheel Corporation, which was a lease that has directly affected tribal land, at least that more or less riverfront property on the reservation. And in that particular case, the court found jurisdiction because of the close nexus with the tribal land and with the reservation, or excuse me, with the tribal land, and with the conduct itself, and defaulting on at least failing to pay the tribe for that. So I asked the court to find an analogy there instead for finding that Thomas and Carl Smith or this court does not have personal or subject matter jurisdiction. But
in that case, didn't both the Colorado River Indian tribes and the Ninth Circuit sustain the tribal court's jurisdiction?
Yes, Your Honor, they did. However, those facts are very specific that the actions that were taking place were within the reservation. If we were to follow that same line of cases, such as Waterville and Marion, in those particular instances, there were two very specific holdings that civil jurisdiction may extend when a non-member or a tribe may have civil jurisdiction over a non-member on non-Indian fee land within the reservation, or a tribal court may have civil jurisdiction in an instance when a non-member over a non-member on tribal land within the reservation. The crucial words there being within the reservation. And quite simply put here, we don't have that locus of conduct to allow for personal and subject matter jurisdiction.
Don't the actions of your client directly impact economic security of the tribe?
Your Honor, yes. Further looks at second Montana exception, whether or not the Smith's actions had a direct effect on the political integrity, economic integrity, or health and welfare of the tribe. We believe that the Smiths would contend they fail on all three fronts. First and foremost, with political integrity. In no way do Smith's actions directly affect the political integrity of the tribe. I would turn this court towards API versus Sack and Potts. In that particular case, the court found that there was a direct effect on political integrity. However, those facts are very distinguishable. In that particular case, there was more or less a coup on the reservation when...
But what about the economic security of the tribe? I mean, doesn't your client's actions have a direct impact on the tribe's economic ability to raise revenue?
The Smiths would still say no, Your Honor. In this particular case, all that has happened is that the Arizona Attorney General has issued a cease and desist letter, Your Honor. There has been no economic impact on the tribe whatsoever. They're still free to go about their business as the stated purpose of the EDC is, and that is of any legal type or business on the reservation or outside of the reservation. So in no way does this actions in any way implicate economic security. Also, it's a very high hurdle they must overcome. In Evans versus Shoshone tribe, the court said that there was a high hurdle in whether or not an individual's actions went to the direct effect or the political integrity, economic integrity, or health and welfare of the tribe. It had to be so that they were catastrophic for the tribe. In this particular instance, we simply don't have the facts and the record to establish that any of the Smith actions are catastrophic in nature for the tribe in this particular instance.
Can you cite to the court any case where a tribal court has been deemed not to have jurisdiction where the parties are in a business or legal services delivery?
Where a tribal court, Your Honor? No tribal court that I'm aware of at this moment has ever looked and found there is no personal jurisdiction over an instance where there are commercial activities between the tribe and its members. However, I would still look to the cabinet ideology. Or actually, Your Honor, I can actually point this court for the Supreme Court case. Plains Commerce Bank versus Long Family Landing Cap, decided by the Supreme Court 2001. In that particular case, the Long family brought actions against a bank in which the bank had refused to continue or refused to renew their loans.
My question was delivery of business or legal services to a tribe.
No, Your Honor, I don't have a case directly on point for that. However, I do believe that this case, or that this court could draw analogies with Plains Commerce Bank in finding that there is no personal or subject matter jurisdiction in this matter. In that particular case, Plains Commerce Bank, where the court refused to bootstrap past activities between the bank and the tribal land, in an instance where we were talking about one loan. In this particular case, Your Honor, we're talking about minimalist contracts that occurred off the reservation and simply don't suffice to amount to minimum contacts or reasonable availment of the Indian Nation tribal courts. We turn back to the reasonable anticipation of being hailed into the Indian Nation tribal court. And quite frankly, the Smiths could not have reasonably anticipated being hailed into Indian Nation tribal courts.
When they agreed to a contract, and both of your clients agreed to a contract that disputes would be tried in any court of competent jurisdiction, is that right?
Yes, Your Honor.
And doesn't that imply that there are several different courts, or at least two different courts, that might have jurisdiction? In other words, have they consented to tribal jurisdiction?
No, Your Honor, they haven't consented to tribal jurisdiction in this particular matter. I would respectfully request that this court would overturn all determination of the trial court in regards to jurisdiction.